Hello and welcome to Encura's Navigating the Changing Federal Landscape series. I'm Kathleen Larmet, Encura's Executive Director, and I'm pleased to have you join us today. This program is being recorded, so if you can't stay the full hour, you can see it on Encura's website later this week. Our speakers will be looking for your questions today, so please note the question mark icon at the bottom of your screen to be used whenever you have a question. And now I'll introduce today's speakers. First, we have Jeff So. Jeff is the Chief Research Compliance Officer at Northeastern University, and he's also an active Encura member who is currently serving as a contributing editor for Encura magazine and as an associate director within the peer review program. Hi, Jeff. Next, we have Caroline Beeman, who is director in the Maximus higher education practice. Caroline possesses over 25 years experience in university costing and sponsored agreement areas. Caroline has led or participated in F&A rate negotiations for over 35 universities. Welcome, Caroline. Also from Maximus, we have Karim, who is a senior consultant for Maximus and is a former national director of the Department of Health and Human Services Cost Allocation Services. Mac was responsible for negotiation and approval of facilities and administrative rates, fringe benefit rates, and cost allocation plans on behalf of the federal government. Welcome, Mac. And welcome to Scott Sheffler, a partner in Venable's government contracts practice. Scott has much experience with federal grants and infrastructure projects and has over 15 years experience advising on federal grant compliance, especially in navigating complex federal compliance environments. Welcome, everyone. Thanks for joining us today. And now I'm going to turn this over to Jeff, who will start today's conversation. Jeff?
Thanks, Kathleen, and thank you to our audience for joining us today in this incredibly invaluable tool that Encura has provided at free of cost. And the Navigating Change series for the changing federal landscape, it seems like every morning we wake up and there is something new to kind of consider. These series have been invaluable to the research community at large in helping us keep abreast of all of these changes that have been ongoing for quite some time. I encourage you, if you haven't listened to the prior two, I believe, webinars on this changing federal landscape, to view the recordings. We'll do our best to kind of segue from those updates into our session today. We're joined by Scott Sheffler, Caroline Beeman, and Matt Karim. We're going to start in that order, and I'm going to please use the Q&A function on the bottom of your screen to ask questions. I'll be monitoring those throughout the session and interrupting our speakers as needed. So with that, I'm going to advance and just let you know, we're going to start with Scott with the regulatory litigation update. And then we're going to transition into discussions with our consultants about the JAG FAIR models, and finally wrap up with the CAS update, and hopefully leave some opportunities for some Q&A at the end. So with that, I'm going to transition to Scott. Thank you, Scott.
Okay, thank you, Jeff. I appreciate it. So thanks to everyone who's here today. And I'll start off with the title slide. It said Venable LLC. I should correct that to Venable LLP. That seems legally significant, but Jeff, my apologies. I laid in wait to drop that on you. Thank you for putting it together. So on the legal update front, there's so much happening that it's hard to choose sort of what to talk about. And the entire group here got together and talked about what might be most useful. And in particular, Jeff, from the perspective of the institutions of higher education, right? Your university and college perspective on the most recent events that would be most useful to discuss. So that's what we've tried to focus on. Please feel free to post questions on anything. If we don't know the answers, we'll say so. And then the last thing I'll offer is a caveat, and maybe lawyers offer too many caveats, but is to say that you'll hear me say by my read quite a lot today, because some of this is relatively new guidance. And so it will take some time to see how it all comes out in the wash. So in terms of areas that we're focused on today, on the legal update side, I want to talk about recent issuances that will impact international collaborations. There have been two relatively significant updates in that area, and I think they kind of go nicely hand in hand. And I suspect that everyone's aware of these. I know certainly with the second one, the NSF research guidance, I've seen a lot of universities themselves putting out notices about this new guidance. And so we'll talk that through. And then I'll talk a little bit about litigation developments. The huge litigation development is a development that's not specifically a grants issue, but it's going to affect all the grants, already affecting all of the grants cases. We've even seen supplemental briefing related to this case, and that's the CASA Inc. case. I'll get into that shortly. But why it's so important is that at the Supreme Court, the federal government won an important limiting case. The Supreme Court instructed that preliminary injunctions could not, or at least only in very rare circumstances, could be nationwide injunctions. I'll talk about what that means and why it's important. Then, as we've all been following, there have been numerous attempts to cap indirect rates. Those have invariably been challenged. The most recent was, I guess, probably 60 days or so ago, DOD issued their original indirect rate cap guidance. It was further implemented later. Again, we'll talk more about this, but that was challenged in court, and as of just a couple days ago, that was enjoined as well. So that's not presently effective for the plaintiffs. We'll talk about that because of the CASA case and the plaintiffs' member institutions. And then briefly, only because it's in the news, I'll mention the Harvard University grant litigation. This is obviously a massive case with implications for everyone. But there's the only action on this case in the last several days has been that there was oral argument on the summary judgment motions, but that gives us an excuse to talk a little bit about that case and why it matters. So we'll do that. And then lastly, I do want to mention some of the things that we've observed, and I guess I should say that I've observed. Just recently joined Venable. I came from another law firm, Feldsman, working in grants the whole time. So as I say we, it sort of is in both of those contexts. But that I've observed, I'll say, in the grant termination context, that I think significant over the last 60 days, and arguments that in some instances have prevailed in those grant termination administrative appeals cases. And then lastly, word on the street is we're going to see some more updates to CFR Part 200. I'm going to take some guesses at what those updates will look like and when we'll see them. And so we'll talk about that. All right, so Jeff, let's go to the foreign subaward limitations. So this first topical area that we wanted to touch on, or at least wanted to cover, was new guidance that we're seeing that will impact your management of foreign awards. So, or projects that involve foreign components. So back in May, many of you may have noticed that NIH issued new guidance that foreign subawards were going to be prospectively curtailed. Ostensibly, the reason for this is a lack of transparency on those subawards. I wouldn't be surprised if events during the COVID timeframe and allegations that were made in the national media had something to do with that. But the basic premise that has been articulated, or the basic reason that's been articulated by NIH for curtailing foreign subawards is that they lack, by and large, NIH lacks visibility into those subawards. And in fact, they even point out that under FFATA, only first-tier subawards over $30,000 are reported at all, at least into the FFATA, what used to be the FSRS system, now SAM.gov. So what NIH had said in May was, well, we're not going to mess around with existing awards, but prospectively, we're going to start prohibiting foreign subawards, and we're going to come up by September with a new structure for how foreign collaborations can work. But in reading the notice, and this is one of the by my reads, when they said we're not going to mess around with existing awards, they don't really mean that, because as you read your way through the notice says that for all new, renewal, and non-competing continuation awards, revisions are going to be necessary. And then, so effectively, right, if we're talking about non-competing continuation awards and renewal awards, we're looking at existing awards as well. And what NIH has suggested will be the prospective approach to these foreign subawards is that those subawards will have to end, and that the recipient, so the university, the college or university, will have to move the funds from that subaward either domestically into the prime and do the work itself, move the funds to a domestic subrecipient, or if that's not possible, if the project can't go on without that foreign subrecipient, actually work with NIH to wind down the project. And so that's what they had said in May. Now, apparently this encountered sort of the reality of facts on the ground. And so there was just a new issuance that gives us an idea of what we should see more of by September. So let's go to the next slide. So apparently there's background concern. I've only seen this through the notice. I'm not aware of it otherwise, that in winding down these foreign subawards, there could be impacts, negative impacts to projects where there's human subjects research ongoing. Because of those potential negative impacts, NIH had to come up with a process, apparently had to come up with a process for restructuring these awards sooner rather than later. My guess is, and again, this is a guess, some of those projects were coming up on their continuation award periods, and so something had to be done. And what NIH has said it will be possible as a new structure is that essentially there will be the prime award to the existing recipient, and now also a secondary prime award to that foreign entity. That'll be a parallel prime award. According to the guidance document, this notice that was put out on July 18th, the total value of the two awards logically can't exceed the amount of the original prime award. They don't say in the guidance exactly how the new award will be issued and how the budget amendments will be done on the existing awards. I have to think with all of the structural challenges, the changes in staffing, et cetera, that we've seen across the federal government, that these types of project changes will probably proceed slowly. Since they're going to require action on the federal agency side. So we'll see how that rolls out. They have also indicated that on these awards where the foreign subaward is going to have to be broken off and made a parallel administrative award with essentially, it sounds like joint reporting, that special flexibilities like automatic carryover won't be possible. One would think that those flexibilities could still exist in this parallel prime award approach. I suspect the reason that it's going away is to have additional visibility into how funds are being expended by the foreign subrecipients, or excuse me, the foreign recipients, these parallel recipients. So how this rolls out between now and September will be interesting to see within NIH. It does mean additional administrative burden and project restructuring, and we don't have all of the details yet on what it's going to look like. If anyone in the chat has experienced this and wants to share with everyone, please, all right, maybe in the Q&A box. I guess it would have to be the chat because no one can see the Q&A box but us. So feel free to share your experience. So I see a couple questions have come in. Has anyone received a new indirect rate since 2/7? Mac and Caroline can probably talk to that. I know Mac is intimately aware of all the details and Mac, if you don't mind, what I'll do is let's hold this question until we get through the legal update piece, but I know you know all the details of who's who and what's what in the ever-changing CAS and ONR divisions.
Fair enough.
So second question, could you also discuss NIH's new training requirement for other support? Should that be standalone training or may it be combined with conflict of interest training? I'm not familiar with NIH's new training requirement for other support. Let's go to the next slide. I am going to talk about NSF's new training requirement for what you could describe as other support. So this is a new research security training requirement. This may be what you're getting at, but if there's something also additional in NIH, I'm sorry, I haven't seen that yet, and I can't speak to it today. I'm going to consider this question answered. So answer live. And I see someone has commented that chat's disabled. So maybe if you'd like to share something with everyone, you can put it in the Q&A with a note too. All right, so there you go. Thank you. Thank you, Tara.
So Scott, I'm going to on that question about the standalone or the other support training. That is a separate NIH requirement that's goes into effect in October of this year. and is requiring training around updating your biographical sketches and your other support forms, things like that. And whether it's a standalone or embedded, that I think that's going to be very unique and specific to your institution, what type of training that you're providing. I don't know, a lot of us rely on city training. I don't know if there's a module on that available. But I think there's a lot of discretion and flexibility as to how institutions incorporate that requirement of training prior to October.
Wonderful. Thank you, Jeff.
Yeah.
It'll be interesting. I think as we talked through, and Tara, I saw you had dropped the link in the chat, so thank you for that as well. As we talk through this NSF version of additional training that's needed, one thing I will mention, again, sight unseen on the NIH training, is that I suspect that as you implement the NSF requirements, implementing them in a way that also incorporates the NIH requirements will probably be the simplest thing to do. So let's talk about the NSF requirements. So NSF has put out a new notice entitled a quote unquote important notice number 149 that at bottom asserts that NSF is going to be more focused on reviewing risk posed from a research security standpoint, and also creating requirements that institutions will have to comply with in identifying and mitigating risk from a research security standpoint. In particular with respect to foreign influence concerns, which I tend to think is very similar to the other support concerns. So there are 6 points to the guidance that's been issued. The first is that there will be research security assessments done by NSF. And what I found most useful or interesting about this aspect of the guidance is that there is an expectation that universities, colleges, universities, other research institutions will retain on file, quote, copies of contracts, grants, or any other agreements specific to foreign appointments, employment with a foreign institution, participation in a foreign talent recruitment program, and other information, as of the time that the grant application is submitted. So this means working with PIs to ensure that not just the information is disclosed, but that you've got copies of any of their agreements as well. I understand many of you may already be doing that, but that's going to be expected. There's a new, and this is the part that dovetails with NIH, or the NIH requirement that was just mentioned. There is now, as of October 10th, going to be a requirement that senior or key personnel, as defined for purposes of NSF grant applications, all complete quote unquote research security training. And they're also going to be required to produce certifications that they completed that training. Whether the certifications will have to be submitted with a grant application wasn't clear to me from the guidance, but I wouldn't be surprised if we see that. Certainly as desk reviews, et cetera, after the fact, I could see those documents being requested. If we go to the next slide, some of these are redundant on the next slide, my apologies, but I'll talk to them there. The other piece of certifications, or the other element of certifications that's going to be required, is that your authorized official who submits the grant application and is authorized to bind your institution with respect to the grant will also have to certify that your college or university has a plan to provide, quote, appropriate training and oversight in the responsible and ethical conduct of research. And the certification will have to also assert that the training addresses mentor training and mentorship, training to raise awareness of potential research security threats, and federal export control, disclosure, and reporting requirements. As we get into the weeds of, well, what training is going to meet these standards, the NSF guidance document helpfully points us back to trainings that are currently available on NSF's website on the following 4 topics. Why is research security important? What is a disclosure and when is it used? A disclosure policy and how will it be used? What actions can federally funded recipients take to manage risk? And is international collaboration encouraged? Those 4 topics, there's a new tool on the NSF website, which is a consolidated version of that training, which you can also download. I find that to be useful as well. So next slide. Additionally, annual disclosures will now be required. And this is actually by statute for all NSF awards. Annual disclosures will be required I believe by all senior key persons that they don't participate in quote unquote malign foreign talent recruitment programs. So these aren't just foreign talent recruitment programs, these are malign foreign talent recruitment programs. Those are the definition of what is a malign foreign talent recruitment program is a bit lengthy and intricate, but it essentially boils down to a foreign talent recruitment program that's sponsored by a foreign government, one, and two, has aspects of it which are which indicate that it's designed to exploit access to research or IP through either unethical or illegal benefits provided to the researchers or others involved in the research. Unethical is an interesting question, what that means, but you should be thinking in terms of conflicts of interest. There's a conflict between that position and the person's position within the US institution that's federally funded. 5, go ahead, Jeff.
Yeah, so there was a question in the Q&A about the training requirement as to whether, as you remember, Scott, the original NSPM 33 rule, only the programmatic components of the rule only apply to institutions receiving more than $50 million a year annually. But the question is whether these training requirements, there is no threshold for these training requirements, whether you're generating $50 million a year or less. That seems to be accurate, that the training requirements are separate from the actual components of a full-blown research security compliance program, and these training requirements will apply regardless of the annual funding associated.
That's how I read it, correct. If you disagree, feel free to say so, but I read these requirements as applicable to all recipients, regardless of funding thresholds.
Yeah, and just a note, I know a couple people have raised their hands. I don't have the capacity to stop the presentation and call on people. I do assume that we'll have time at the end to call on those that have their hands raised. So I'm not ignoring those who have their hands raised. So keep that in mind. Thank you. Go ahead, Scott.
Thank you. And I'm going to do 6 and 5 in reverse order. So 6, NSF can't make awards to any institution of higher education that has an agreement with a Confucius Institute. There's a possibility to obtain a waiver, but I suspect that most of you would prefer not to be asking for that waiver in the current funding environment. So that's 6. And then 5. So we've been talking about primarily, with the exception of this Confucius Institute issue, we've been talking about the senior personnel and what agreements they have in place, what relationships they have. There will now also be, at least under this guidance, a specific annual disclosure obligation for the institutions themselves. And this disclosure obligation is very broad, that any institution that receives any financial support in excess of $50,000 from a foreign source associated with a foreign country of concern will have to report that contribution through a portal that's supposed to be set up. I don't think it's set up yet, by September 1st. The way that this disclosure trigger works is that it's a foreign source associated with a foreign country of concern, right? So it's not just directly necessarily from that foreign government. It could be other actors on behalf of the foreign government. And also it's if that contribution is received by the institution of higher education itself or by an affiliated entity like a foundation that supports the institution of higher education. So there's not an intermediary way, at least no good intermediary way, to get out of the reporting obligation. The good news is this is fairly narrow in the sense that foreign countries of concern are currently defined as the People's Republic of China, the Democratic People's Republic of Korea, right? So North Korea, Russia, and Iran. Technically, the Secretary of State can designate other countries, but those 4 are the big 4. All right, next slide. All right, and then litigation developments. So this CASA Inc. case, I already touched on this, and I see we're getting close to the half hour. This was a very, very significant case. This is one of those Supreme Court cases, which is very fun for us lawyers to read because the justices actually look back 250 years to the founding of the Republic and what British common law provided for as remedies when at the time that we adopted the Constitution. The long and short of the case is that according to the Supreme Court, except possibly in very limited circumstances, federal district courts don't have the authority, don't have the power, or again, except possibly in very limited circumstances, don't have the power to issue quote unquote universal injunctions, what sometimes are called nationwide injunctions, meaning that when the plaintiffs in the case seek relief based on the lawsuit that they've brought, and as preliminary relief, they ask the court to prevent the federal agency from carrying out, implementing, carrying into effect the particular policy that's at issue based on whatever that final agency action is. When they ask for that relief, the scope of the relief, both preliminarily and as a permanent injunction, will only impact the plaintiffs themselves. So this is really significant in the cases that we've been seeing in the grants context, because many of the injunctions, grant terminations, etc., have been nationwide injunctions affecting more than just the plaintiffs. When that's no longer the case, there's far less of a barrier. It's not a policy statement, it's just a factual statement. There's far less of a barrier to federal agency action that has the desired effect, even if maybe it doesn't fully comply with the law and how it's been implemented. The agency is only going to be stopped with respect to the plaintiffs who bring the lawsuit. Now, one caveat on that, or one important takeaway of that, and I have it here in my practical takeaway point, is that for those of you who are members of various associations of universities, those associations, to the extent that your membership in the association has something to do with the lawsuit, they can still bring cases, at least in theory, they can still bring cases on your behalf. And to the extent that they're seeking relief for their members, that's still a possibility. There's still a possibility for class actions to be brought. But outside of those scenarios, it's going to be a lot harder for any individual institution to obtain relief if they're not actually a member of a particular lawsuit. So those associations you're members of are going to increasingly become your best friends, I suspect. So the Association of American Universities versus Department of Defense case, the main takeaway here is that we had the Secretary Hegseth memo that instructed other members of DoD to start the process of capping indirect rates at 15%, similar to what we've seen right with NIH, Department of Energy, NSF. And then there was a follow-on action by Undersecretary of Defense Michael Emil starting to carry out that directive. Association of American Universities sued on behalf of its members to say that that was an illegal cap on indirect rates. They prevailed. They obtained an injunction against, I think, in fact, goodness, I didn't put this in my slides, but I believe at this point, it's just a preliminary injunction. It's not final resolution of the suit. But that preliminary injunction, consistent with the CASA case, applies only to the plaintiffs and their member institutions. So again, those who are members of the various university groups that sued will be protected, whereas those who aren't won't be protected. And yet, I'm certain it's only a preliminary injunction. One of the interesting things that comes up in this case is an APA action, Administrative Procedure Act action. Under the APA, you can challenge final agency action on the grounds that it's arbitrary, capricious, or contrary to law. One of the interesting features of the APA is that in the statute, it actually says that you can seek temporary relief in the form of the court, quote unquote, staying the agency action until the suit is over. Most of the precedent, at least that I'm aware of, on those APA stays indicates that they're the functional equivalent of a preliminary injunction. But the difference between the CASA case and these stays is that the Supreme Court in the CASA case said, based on historical precedent and remedies available throughout the history of the Republic, and at the time the Republic was formed based on English common law, there wasn't really such a thing as a universal injunction, so we're not going to find that that exists in equity presently. Well, the APA stays in statute, so the court in that case actually says, though we're not going to issue a stay, we have some doubt that the CASA case would actually impede our issuing a stay that would have universal or nationwide effect. So that's something we're likely to see more litigation on. Really interesting circumstance. And then lastly, the Harvard case. The big takeaway here, we can talk a little bit more about it if anyone wants to, but I want to make sure that we get to the indirect rate discussion, and I have one more slide after this, is oral argument took place on Monday. That case, there is no, the plaintiffs did not seek a preliminary injunction. Harvard University didn't seek a preliminary injunction in that case. Rather, they moved very quickly to request. They said they made the argument that, look, there's no dispute over the material facts in the case. The government agreed. And so there's a motion for summary judgment, which is rather than having any development of evidence, the parties agree on the facts. And the questions before the court are purely legal questions. So they've moved for summary judgment. The government opposed their motion for summary judgment and cross moved for summary judgment in their favor. And the parties are looking for a judgment by early September. That's their goal. Oral arguments complete, and so it's possible that very soon we will see a decision in the Harvard case. The basic premise of the case there is whether, based on a combination of Title VI like, I will say Title VI like bases, and the basis for termination of awards that the government has been continuously asserting of the program or the grants no longer effectuate agency priorities, whether the federal government has the ability to simply terminate Harvard's funding under those provisions. Harvard is arguing, well, if this is Title VI based, in fact, regardless of what the grant agreements say, we should get Title VI due process, which they argue hasn't happened. And also, Harvard is making the argument that this is punishment or retaliation by the federal government in improper ways for exercising their First Amendment rights. My guess is what we'll see, well, it's very hard to predict, but I tend to think we'll see the court avoid the constitutional issues and focus on the Administrative Procedure Act, whether the government's actions were arbitrary, and also focus on whether Title VI is a mandatory regime that has to be used by the government to terminate grants when there are allegations of things like, at least according to what's in the news and what's in the filings, anti-Semitism, etc. Okay, next slide.
Scott, before we go on, there was a question about what someone was looking for a good reference or guidance around the definition of a malign foreign talent recruitment program. Beyond the federal definition, I know that a lot of universities have embedded the definition as part of an existing policy or a new policy, or in some other cases, they're having PI certify that they're not participating in a malign foreign talent recruitment program, and they provide some definition. I think the easiest way to consider a MFRTP is the features that our government is worried about, right? Not just the collaboration, but is there an ongoing requirement to share data and intellectual property? Is there a requirement to establish a pipeline of students between the universities and the, relevant universities? Is there a requirement to develop a separate lab in a foreign space to do similar work that you're doing in your US campus? So there's a lot of different features that can qualify as a malign foreign talent recruitment program. But I think if you can, Incura and all, Google itself can provide you a number of examples of the definition and how it's being incorporated into the day-to-day kind of research administration. Do you have anything to add to that, Scott?
The only thing I would add, so I agree wholeheartedly with everything that you said. The other sort of feature I would add, or thing to watch out for that I would add, is you described what's the foreign institution getting, right? What mechanisms are in place to try to basically capture research or research data or intellectual property? The other aspect of this, and maybe this wouldn't be in the definition, but that I'd keep an eye on, is, well, what's being provided to the researcher? If the thing that the researcher is receiving seems to be far in excess of the value of what the researcher is doing, that could also tend to suggest a conflict of interest.
Thanks, Scott.
Now, how do you tell a researcher, especially one of your top researchers, that they're being paid too much for what? Right, that's an awkward conversation. But I'd say that sort of, what's the value proposition could tend to indicate conflicts as well.
And as you were talking about grant terminations, there was a question in the Q&A about one example of a grant that was terminated, but there are invoices outstanding and without any payment whatsoever. It's encroaching 120 days now outstanding. and they're really nervous that they may never get paid. So I'll leave that to you as you go through your grant termination section.
Certainly, and you know what I'll do is I'll speak to that first, that you're not alone. Obviously, the federal government has an obligation under 2 CFR 200.472 to pay allowable termination costs. You got your 472A and your 472B costs. 472B is the straightforward administrative costs of wrapping things up, preparing final reports, etc. That shouldn't be too much in dispute, but certainly we have seen agencies simply refuse to make any payments after the termination date. Then you get your 472A costs, which are the non-cancelable continuing costs that you're experiencing, notwithstanding the fact of the abrupt termination. Those are always in negotiation, and we're seeing a lot of trouble recovering those thus far. What I would say is one of the challenges in the federal grant system is that every agency has its own appeals process, if it has an appeals process. And so you have to become familiar with that. But normally, those processes will provide you only after you submit. So once you've submitted your closeout claim, if it's denied, you'll typically, under the various systems various agencies have only 30 days to appeal. It's a good idea to invoke those rights. And oftentimes, in my view, especially with significant disallowances, it's a good idea to carry through with administrative litigation on those. Separately, at that point, if the administrative litigation either doesn't succeed, you're looking at going to federal court, or especially with some of the arguments the federal government has been making, and somewhat successfully, over jurisdiction recently. That's often a court of federal claims case. I would say that's a good chance it's going to be a court of federal claims case at this point. Historically, a lot of those cases were brought under the Administrative Procedure Act in district court. But that's sort of a multifaceted answer. The first part is, yes, you should be entitled to probably most of those costs. I haven't obviously seen what costs you've submitted under 472. The second part is, if you're not paid, as soon as they're actually denied, it's a good idea to appeal the denial, at least if you have the wherewithal to do so. And the last piece is, you may still face a fight with the agency. I like to think that if you were to have a good argument for those costs and you file the appeal, that's going to potentially open up a path to negotiating something that everyone can live with rather than litigating the appeal. But right now, it's hard to say. Every agency's culture is a little bit different on those points. Some things we have seen in the termination administrative appeals with some agencies, certainly I can speak to NIH, the filing appeals under the 42 CFR Part 50 Subpart D NIH grant appeal process has in some cases led to reinstatement of grants, which is good. I have heard of other agency appeal processes. I've heard, well, I don't want to speak more specifically than that, but other agency administrative appeal processes leading to reinstatement of grants. And so 2 months ago, I think a lot of lawyers, if you said, is there any chance that this appeal succeeds? We weren't sure because of the changing environment on the federal agency side. Who was going to make the decisions? Was it possible to actually get relief? The answer seems to be yes, it's possible. It's not easy, but it is possible. The second thing that I wanted to mention is I know from personal experience that Department of Education, for some of the grant terminations that happened in Department of Education, their Office of Hearing, I don't think this is published through Westlaw or Lexis yet, but their Office of Hearings and Appeals has issued a number of decisions now where they have confirmed that they do have jurisdiction over grant terminations where the grant terminations are not grant programs that fall under the Higher Education Act. The reason they have concluded this is the General Education Provision Act that creates appeals processes for grant withholdings, they have determined applies. So still we'll still see how that all plays out. But for now, grant terminations in Department of Education, if they're not Higher Education Act programs, presently you can appeal those to the Office of Hearings and Appeals within Department of Education, which is good. It's helpful. They're ALJs to hear those cases. And then lastly, we're looking at 2 CFR Part 200 being updated. That's a rumor in Washington right now. If it does get updated, I tend to think two things we're going to see the administration add will be more rights to terminate grants and more rights to cap indirect rates. So we'll see what happens there. Keep an eye out. Caroline,
Thanks,
I'll
Scott.
turn over to you, and thanks for giving me so much time.
Yeah, Scott, well, before we go to Caroline, someone asked a great question, which is what does financial support from China, North Korea, and other countries mean? And that's a great question. And because it's support can mean anything, right? It's not just gifts to the university. It could be tuition support as well for students. It could be funds for a chair to be named after someone. It can come up in a variety of um, mediums, and we do this exercise for Department of Education 117 reporting twice a year, and NSF reporting once a year with different categories. But it's an outreach to not just your colleges, but the advancement or development piece to your institution to see what kind of gifts have come in, what kind of and we can't just limit it to government support, like these official government support, because many of these companies, corporate entities, and institutions have ties to the government. So it's really broader than that, and we're seeing institutions experience adversity. Most recently, University of Michigan being investigated for what's perceived to be a disparity in their 117 reporting to Department of Energy, and what is perceived benefits the university has received insofar as international collaboration. So it's an important definition. I think we're all trying to get it right and be overly transparent in our reporting. It's more important now than it was 10 years ago, clearly. So I think as far as I'm concerned, it's a collection of information and data from across the university in order to satisfy some of these reporting obligations under DOE and NSF. Now, anything to add to that, Scott? Or
No, thank you, Jeff.
yeah, all right. Okay, so now, thank you, Scott. We're gonna transition to Caroline. And Caroline, I'm gonna get your slides up.
Thank you. So before this slide, Jeff had asked me if I knew anything about the federal funding, the 12 appropriations bills that are currently making their way through the system, except that the whole system stopped yesterday because we don't want to vote about Epstein or whatever. The process will continue. I found a website. There's obviously no time to go through this, but the AAAS.org, that's the American Association for the Advancement of Science, published on 15 July on their website an article that's called FY 2026 R&D Appropriations, Federal R&D Estimates. And they are updating this continuously with the Senate the president's budget suggestions, the Senate's appropriations bills, and what's going to come out of the House. And then, of course, it all goes through the process. So overall, at this moment, they're estimating 20% less from all the agencies for federal R&D. You can look on that website for any particular agency, any kind of research. It's a great website. So if you want to know more about what's happening, and it happens and it's changing continuously, I highly recommend that website. I put it in the chat there. I wanted to talk about the FAIR models. It's about an hour and a half worth of information I'm going to squeeze into 5 minutes if I can. So what is the JAG? The JAG is the Joint Associations Group. It is 10 higher ed associations that got together and said, look, this is what's happening to indirect costs, what we called F&A, and now we call indirect costs. There was this rate, nobody could understand it. Everyone was confused about it. And now they want to cap indirect costs at 15%. And institutions stand to lose hundreds of millions of dollars if they do that. We need to get ahead of it the associations came together and said, well, they're going to change something. Let's see if we can come up with a model that might be more acceptable to everyone. And so they came up with what they call their FAIR models. FAIR standing for Financial Accountability in Research. FAIR. They came up with a couple of different models. They put it out to the community to comment on it. Almost 200 universities responded with this is what they saw with their analysis and their suggestions. They took those and in a couple of days synthesized it into something that they took to, I believe, OMB. They got input from OMB, maybe not on a model, but just on the concepts. And they came up with their third model of what it is they would like to propose to the powers that be. Who are those powers that be? The different committees, the OMB, different agencies, and it looks like there actually may be some traction there. People have said, well, who's going to listen to them? Apparently, in the DoD appropriations bill, there is a mention of extramural research community working with the federal government to come up with some solution to how do indirect costs get reimbursed. So somebody's paying attention, maybe? Now, this FAIR model, which has been out there only a little while, and again, has changed. This is the July 11th version. Pretty much everybody hates it. But you got to have something else. We are not going to be left with what we've got now. Things are going to change. This is, if you ask me, a best effort at coming up with something else. What does it have in it? Well, it changes all the names for one thing, and it's describing cost as a percentage of the total budget, because everyone gets confused when you say I have a 60% F&A rate. They want 60% of the federal dollars are going for something called indirect costs or F&A, and they're incensed. Well, that is not what 60% F&A rate means. So they're changing it to be a percentage of total, which then when they say, oh, 40% F&A rate, yes, that's 40% of the total. So changing just how it's described and changing the words. So I don't expect you to be able to read what's on that. I have a suggestion if you want to read the executive summary of the FAIR model. AAU.org has published this on their website. Coger.edu has it on their website. I'm sure APLU has it, AAMC. There were 10 different associations that came together. I'm guessing just about all of you belong to at least one, if not more, of those associations, and you'll be able to find the executive summary of the FAIR model on your website if you really want to know more about it. In a nutshell, this is what they're saying. Instead of having direct and indirect costs, we would have direct costs, which now we're going to call research performance costs, whatever they call it, the direct costs. And then we'd have this GRO. That GRO stands for General Research Operations. That's your HR, your benefits people, your payroll people, your accounting people, your budget people, your president's office, all those general kind of, we call them G&A kind of costs, as well as those higher level costs that go over the whole institution. That's GRO. Which, and you can't see it on my slide unless you have a really big screen, they're suggesting would be 15% of total cost. It's like, well, that's great, but that's the cap that they are suggesting. So I'm not sure asking for anything more is going to get you anywhere. They're then suggesting in this FAIR model, you'd have two options. On top of that 15%, general research operations costs. You'd have a base option, which is then, and then 10% more that's going to cover research information services and what they're calling essential research performance facilities or facilities costs. It's just another 10%. So that sounds like 25% of a total budget. It's like, yeah, I'm not sure anyone's gonna, in the federal government will buy off on that, but the concept is there, a standard amount, and then this other little bit, I'm not sure why they're separating it, just because it presents better that way. If you look at my slide here, you'll see on the base option, there's all the blue, that's the direct, and there's a couple of red lines there. Those are things that currently are in your administrative costs, in your F&A rate, and they're suggesting, well, maybe you could charge those directly to the grants. Those would be things like the regulatory compliance, your IACUC, your IRB, your clinical trials office, and also your AMOR, award monitoring, oversight, and reporting, some of that pre-award and post-award stuff. That would be optional. I mean, if you can figure out how to charge those directly to grants or come up with a rate through a service center to charge or recharge center to charge those to a grant, it would be a direct cost rather than an indirect. So basically what they're saying is we're going to take a lot of these costs that are indirect in our indirect rate now and have them charged in the directs directly to the grant. That way, hopefully, we can come out close to whole. So this is all based on different types of research. That's that ERPF, the Essential Research Performance Facilities. What kind of facility are you doing it in? An office, a research lab, a VSL, a vessel, a different campus. And they're saying rates would be project specific, which has people kind of going, oh my gosh, look, I got 8 minutes. Oh my gosh, what am I going to do? It's kind of like the concept you have now. You have a sponsored instruction rate, you have a research rate, you have an other sponsored activity rate, and you have an off-campus rate. Most large schools have 4 different rates right now. And each grant gets only one of those 4 different rates. So every time the pre-award office looks at it, they have to decide specifically for that project, what is the rate? Same idea here. Specifically for this project, is it the office rate? Is it the research rate? Is it the vessel rate? Whatever rates it is you have. Recharge centers are basically going to account for a lot of this stuff that's going to be charged directly. Let's go to the next slide.
Yeah, just so everyone knows, we are running behind. We're going to actually extend this webinar probably around 10 minutes or so. If you have to drop off, keep in mind that this is being recorded and the recording should be available on the Encura home webpage probably by Monday. So very soon if you can't join us. So thank you if you have to leave.
Okay, thanks, Jeff. That's wonderful. This is just kind of my public service message for those people who aren't cost accountants and don't love algebra and don't love arithmetic. Not really math, it's arithmetic. This percentage of total budget. Percentages, I find confuse people who are not very math oriented. That would include my husband. So when I say 25% of total budget, it sounds like a lot smaller number than what I'm getting now. Well, if you convert that into what we do now, which is a percent of direct, that's 33% of total direct. That's exactly the same equivalence. Now, right now we have a percentage of modified total direct. So actually it's even more than that when translated. And how do I get from a percentage of total budget to a percentage of total direct? And I've got the 2 little boxes. How do you convert from percent of direct to percent of total? Or if I know the percent of total, how do I get back the other way to percent of direct? And that's kind of all I want to say about this. It's like, you'll get the slides, and if you want the formula, there it is on the slide. I've got one more slide, and that's about the way we submit our F&A proposals now through, the next slide, please. Through for HHS-CAS, the cost allocation services. So everyone except 39 institutions submits, if you're higher ed, submits through HHS-CAS. So 39 submits through ONR. So currently anything new you're submitting has to go through their, what they call their ICAS portal. I don't know what ICAS stands for. And no, you can't read the pictures, and you're not meant to. It's just a picture of, if you go to HHS PS portal.icas, hhs.gov. You can just Google ICAS portal, HHS. It'll give you a link there. That's where you go to submit your fringe benefit proposal, your F&A proposal. First thing you have to do is register. Scott was talking about portals. It's like, oh yeah, the rollout of this portal was something. I think it's getting a little bit better. Registering itself was a big problem for people. It still is a little bit difficult. But there is, if you look on the right side, support_ICAS at psc.hhs.gov, a place to go for help. From what I have heard, they will actually respond and they will help you get registered. And it's like, oh, well, we'll fix that. That didn't work. A lot of the we'll fix that didn't work is starting to get resolved. So people are starting to be able to get into the system and actually submit. Then there's the whole submitting, and not even going to talk about that. That could be another hour. And I myself have not been in the portal yet, but the things they ask you for and the way they ask them are a little bit complicated. We'll go with that. So remember, going forward, fringe benefits, F&A, you got to go to their portal. And again, just Google it, ICAS portal, hhs.gov. That was me. Let's go to Mac.
Good afternoon, everybody. So I'm going to run through this real quick. First of all, ICAS stands for Indirect Cost Allocation System. This is a new system which is customer facing, and the rate agreements are available in real time. Unfortunately, the timings weren't that great. It kicked in when Doge was, in full bloom. Anyway, enough on CAS. As you know, HHS is the big kahuna. We issue more rate agreements than anybody else, about 2,600 per year. Right now, as I've said before, we're starting pretty much in the twilight zone. As we all know, April 1st, 2025, HHS had visitors coming in and basically just telling us what to do. We had 4 offices: New York, San Francisco, Dallas, and Rockville, Bethesda at the time. And so right now, the directive was to shut down the East Coast, West Coast, and that created a lot of, stoppage to work, if you will. I mean, things were pretty slow to begin with. This certainly didn't help. So anyway, that said, somebody had a question if there were agreements were being issued. Yes, the answer is yes. We are, albeit, trickling slowly, but they're issuing rate agreements. Obviously, we've lost the staff that was in the East Coast, West Coast offices. So we were kind of down to the Dallas and the Rockville office. And even there, we've had some people that had retired. And so therefore, things are moving, but they're moving very slowly. For what we've got, like I said, being down to 2 offices, we are trying to get as much work out as possible. I keep in touch with on a regular basis to see if there's if there's any progress in terms of hiring and so forth. It seems like there's a 4-to-1 ratio that's coming up. It's for every 4 that you've lost, you may be able to get 1 position back. But that, again, hiring is, as we all know, HR is a big challenge, no matter what. So it's going to be a while before we start to see bodies coming in that are going to be able to do the work and provide the service. So that said, let's go on to the next slide. There was also a question about the OMB and the 2 CFR 200. Yes, OMB is working on it. Just FYI, I think we will see something. I don't know exactly when. Different dates have been put on the board. We'll have to wait and see how that plays out. There certainly is, it's work in progress. I can tell you that. So, as
Mac,
far as yes.
we should still be able to comment though on a proposed rule, right? If there are proposed changes to.
See, that's a question that I had raised before. The NPRM, the 60-day notice of proposed rulemaking, that's typically how it works before something gets put into the CFR Code of Federal Regulation, before it gets codified, promulgated into the Code of Federal Regulation. So I don't know if they're going to give us that benefit of the doubt. And the only reason why I can think they may bypass that is because you have a baseline product already. We've got the uniform guidance. So they're going to make some edits to the existing document. So they may just bypass the whole process. I mean, given the way things are going, or there may be a very narrow window on that one. I don't know yet. That remains to be seen. Scott may be able to comment on that. I don't know from a legal perspective if they can go ahead and codify something. Scott, do you know?
If it will be a binding rule that sets the rights of the public, the general requirement, this is by statute under the Administrative Procedure Act's rulemaking provisions, they would have to go through notice and comment rulemaking. There is an exception for rules pertaining to grant agreements. And it's possible that they could argue that this falls under that exception. You might remember 2 months ago when the NIH rate cap litigation occurred, there were a lot of arguments about this thing called the, it was named after somebody, so the something or other waiver, but there was, HHS had said, even though the Administrative Procedure Act requires notice and comment, accepts grant agreements from notice and comment rulemaking when it's grant terms and conditions, the Department of HHS had said they would still go through notice and comment rulemaking. That's been revoked. So it's possible that that's all a lead up to trying to change these grant related regulations without notice and comment rulemaking. But we don't know. The baseline rule is notice and comment rulemaking. There's an exception in there for grant related rules. So it's hard to predict. If they're not going to follow notice and comment rulemaking, it's because they're invoking that exception.
And I tend to agree with that, Scott, because I think they're going to try to bypass it using that caveat, that's in there. So again, once it goes into the CFR, then I think we may be bound by that in terms of what rate we can get to charge and so forth. So anyway, going back to the org chart, obviously there's more to come on that, and we'll keep you informed on that as the time goes by. There are two offices, the Rockville office, which is the headquarters, and also the Dallas office, which is where I'm at here in the Dallas Dallas. So you can continue to submit your proposal through the HHS-CAS, which is fine. If you don't have any luck with that, you can certainly send it to the director's office, which is Lola, or even to the branch chief, either one. That'll work. But my recommendation would be to go through HHS-CAS. I would highly recommend that. Okay, and that's for the org chart, the CAS org chart, and then because we've got the ONR, our counterparts, and I saw somebody mention something about one rate agreement was issued for MIT. That would be the ONR office. We obviously don't, as you know, deal with the ONR schools, which is a handful of those. So yes, the work's going to continue, albeit slow. My suggestion would be to continue putting in, submitting your proposals. And, regardless of what happens in the future, I think at least you'll have your continuity in terms of being able to trend something from one year to the other year. But that's pretty much. Any questions, Jeff, that we can respond to? You have your mute, Jeff.
I'm going to stop sharing for a second. So I have a question for Scott, if we have time. Someone wanted to revisit the Department of Defense indirect cost rate case and the timeline for that. They're a little confused as far as what next steps are in that case.
Certainly, I was just typing an answer to them. So
Okay.
On the 18th of July, the court issued a preliminary injunction. That means that for the time being, until the case is decided on its merits, the DoD indirect rate cap won't apply to the plaintiffs, or to the extent that the plaintiffs are associations of universities, to their members. So it's that next step would be the Department of Defense should be submitting to the court its administrative record if it hasn't already. And then the parties will probably file cross motions for summary judgment based on the administrative record to get to a final outcome in the case. In a case like this, I'd say you're looking at somewhere between 2 to 4 months to get to final resolution of the case, but it's hard to predict depending on how it goes.
Thank you. And someone's been very patiently raising their hands for quite some time, and I wanted to provide an opportunity for Brian Gambacorda to ask a question if he still wants to.
Disabled.
I can't get in the meantime, Scott, I think you and I talked about it just yesterday. What other changes do you foresee if you had to put your magic hat on and guess what might be other changes to the uniform guidance might be in store for us? What do you anticipate?
The only two that I would say from what we've seen from the current administration we're likely to see attempted are, one, easier grant terminations. There's this history of, in 2020, terminating grants on the basis of no longer effectuates agency policy was our priorities was added as a termination basis, but that was pulled out last October as a basis in 2 CFR Part 200. I think we'll see that reinserted. The second is I think we're going to see a change to the language around when indirect rates could be capped, or at least when budget line items pertaining to indirects could be capped by agencies without having to go back to OMB for a deviation. That's totally personal speculation. I have no inside knowledge. I haven't heard colleagues talk about this. That's my guess of what we'll see. One other area, if they're trying to streamline, that maybe we'll see is, and we see this every time the uniform guidance is updated, is at least lip service to performance-oriented metrics. If they want to go down that road and really do it, what we'd see is more fixed amount awards. But I'd say, who knows if we'll see something like that. I'd say it's possible.
Thanks, Scott and Mac and Caroline. Thank you all for your time today and for joining us. And I'll bring it back to Kathleen.
And thanks to you, Jeff. We appreciate your time today. Caroline, Mac, Jeff, Scott, it's been great. Thanks so much. Thank you for joining us. We'll be off in August and we'll see you in September. And we hope to see you in August here in Washington, D.C. for our 67th annual meeting. Thanks so much. Until then, have a good day.
Thank you.